to need 1 hour is because the Commission has itself now conceded that a postponement is appropriate. The Commission has chosen a date of 14 August 2026, and that means the postponement application which has been brought by my client in respect of his evidence for the 15th of July rolled over to the 17th of July, rolled over to the 24th of July, is effectively unopposed.
Yeah, but the crucial issue is that the effect of what we have before us would be that Mr. Carrim never ever testifies. So that's a serious issue that needs to be dealt with.
I'm not sure I agree with that characterization, Chair, but I accept the point that you make that the postponement as to whether or not it's by a postponement to a fixed date as opposed to a postponement not to a fixed date but subject to some...
But with what we have before us, the doctor's report, the effect as we sit here now is that even on a later date to which we may postpone, we will be told the same thing.
Indeed, sir.
So ultimately the effect will exactly be what I'm saying, which is that Mr. Carrim will never ever testify.
Well, I don't know if I agree with the characterization that you'll necessarily be told the same thing, because what you'll remember from the treating doctor's report to you, and again, I'm not going to go into the specifics of that in light of the ruling on the in-camera issue, but what the treating doctor says is that the position of my client is dynamic and it is subject to change. And that's why one of the things that the treating doctor himself proposes is to account to the Commission under oath once every 2 weeks to update the Commission regarding the client's position and whether he can or cannot testify. It's also why the doctor's evidence under oath is to suggest that there are alternative means that can be explored.
Continue.
No.
I wanted to say, based on what we have, an educated guess would lead one to say, even though you've just made the submission that you've made, we can't hold our breath.
No, fair enough. But I was responding to the characterization that you'll necessarily be told the same thing in future. It was simply to say that that's not entirely correct.
I guess
you may be told the same thing in future, but you may not be as well.
I guess I'm saying exactly the same thing I said earlier when I say we can't really hold our breath.
No, indeed so.
Yes.
Indeed so.
Can I also just check your characterization of where and how we got here? You say the application for the postponement is not opposed. I don't see that is correct, a correct proposition. You're asking for a postponement to an indefinite date, which is completely subject to what the treating medical person is going to determine whether he ever comes back and on what date he comes back. But more importantly, you are bringing an application for a deferral of Mr. Carrim's evidence to an undetermined date. That's your application, as I understand it. And the evidence leaders oppose that. And in their opposition, they say, we want him to come back on a specific date. So there is an opposition to your application.
Yes, it's a limited, that's the word they use in their correspondence of about the 23rd of July, if I'm not mistaken, where they say it's a limited opposition. And it's, if I can say this, the difference between my learned friend and myself is the mechanics of the postponement. What's not opposed is that a postponement is appropriate now. It's just subject to whether, as Commissioner Baloy correctly says, it's an open-ended date or it's a fixed date. And that's what I was saying to the chairperson as well. So it's not to say that it's no opposition in the sense that there's no disagreement. There is disagreement, but it's on the mechanics of the postponement rather than the narrower question that I was addressing, which is that the postponement being sought today, in principle, is unopposed between the Commission and ourselves.
But if it was being opposed in the wide sense, whatever that means, the consequence would have been that if it was opposed and opposed successfully, the consequence would have been that he comes and testifies today. He's not going to, he's not here. So the distinction is a technical decision really which makes no difference whatsoever. Fact of the matter is, you are seeking his evidence to be deferred. We are here today. You say indefinitely. They say, no, he's not getting the postponement that he wants. We want him to be given a date to come and appear. So I don't understand the technical differences, but at this point I wasn't engaging on the technicalities of indefinite, and I was simply saying, but this application is opposed. That's the position. Your application, as formulated by you, is being met with an opposition.
Yes, it's described as a limited opposition in paragraph 1.14 of the attorney's letter on behalf of the Commission of the 23rd of July. So that's where I was going to focus the bulk of my submissions, on the limited nature of the opposition, rather than whether or not a postponement today ab initio is being opposed. I think that's where I'm directing myself, Commissioner Baloyi.
Yes, all right. But you accept it is opposed?
Yes,
right?
yes,
Okay.
within the confines of what I've said. Yes, absolutely so.
Thank you.
I'm not, it's like in litigation where the parties might...
Please, I think,
Okay.
Please go ahead.
No, thank
please
you.
Continue.
I'm indebted. So by means of introduction, that's the first of the 12 points I wanted to make. The question in front of you is actually a narrower question about the mechanics of this postponement and what it ultimately looks like, whether it's to a fixed date or whether it's to an indefinite date. And what I will say to the Commission in that regard is two things. Number one, you have our submissions on paper justifying why it should be an indefinite date. But obviously the Commission, through the evidence leaders, have put up a series of considerations as to why it should be to a limited date. And practically speaking, that's something that, practically speaking, that's something the commissioners will apply their minds to and make a ruling on. And all I'm going to say is that the mechanics of that ruling will be whatever it is. I'm not going to focus my submissions on the harder element, if I can call it that, which is to say it should be to an absolute indefinite date. I'm going to focus on my submissions on the appropriateness of the postponement in the circumstances in light of the evidence that you have in front of you. So that's where that's what I'm going to focus on. Can I just say that, and the reason for that is because of the limited nature of this opposition, but I'm not going to repeat myself. Can I say on the second point, please, that there are two potential directives that consider granting in respect of the proceedings today and the argument as it unfolds in front of you today and before my learned friend has an opportunity to address you. The first one is that I'm not sure what the status of these application papers will be or become once the Commission makes its decision on the postponement. But the request is that should any part of the record become public, that it is subject to the limitations already imposed by the chair in the in-camera ruling. So that is that the record of papers itself must not reveal or identify the very things that the chair has said we're not allowed to say in the oral argument, because that would effectively render that ruling pointless if the paper record reveals the very things that we aren't allowed to refer to in the oral hearing. I don't think that should be controversial. That's actually asking for a logical extension of the chair's ruling as it applies to the papers. The second directive, and this might be the more controversial one, is I know my learned friend has given me advance notice that she intends to rely on certain CCTV camera footage. I don't know if that is still the case, but there are other pieces of information that the Commission has subsequently shared with us that may also need to be treated carefully. In particular, there is mobile data geolocation information which may or may not be projected. I don't know if my learned friend intends to project it on the screen when she makes her submissions. But if she does, the point that I would request the Commission to please consider and make a directive on is some of that information contains highly specific GPS coordinates. And the reason that when it is projected onto the Commission's screen, if the Commission intends on doing that, to prevent the publication of exact GPS coordinates is because it opens the threat that the GPS coordinates, when projected onto the screen, can be used to reverse engineer exact locations. Obviously, if the CCTV footage puts my client at a Durbanville mall, I can hardly complain about that. But I'm raising a concern in respect of the facility, for example, and geolocation data near the facility. I would also humbly request that in making such a directive, when my learned friend is going to refer to or reference the suburb that the facility is located in, that the name of the suburb is not mentioned explicitly, because it doesn't take a genius to run a Google search or a ChatGPT search to ask it what medical facilities are in the particular suburb, with the effect that it gets close to the very things that the chair has said should not be identified. So I don't know, practically speaking, when chair will make those directives or consider them, but I think even in just flighting the fact that those are the directives I'm asking for, I'm hoping my learned friend will approach it with some degree of sensitivity, even in the absence of a directive. That's not to say my learned friend mustn't say what she wants to say or use whatever footage she does. I'm just raising the concern about certain of the information which is not necessarily expressly covered by the in-camera ruling might nonetheless be utilized to undermine the very purpose of the in-camera ruling. And that's the second request that I make. Chair, I'm in your hands as to practically whether you want me
I
to
think
go
for
on.
now, yes, for now, please continue
Okay.
with your argument. I don't want to
Yes.
eat into your time. What we will do, we'll raise this issue before Ms. Hassim starts arguing.
I'm indebted.
Yes, I don't think there's an issue with the
The first one, I
with the
hope.
first one really, but we can't make rulings piecemeal. Yeah.
Yes, indeed,
Yes,
indeed,
yes,
indeed.
yes.
So that's point number 2.
Please continue.
Thank you, Chair, I'm indebted. Point number 3, now talking about the video footage. With all due respect, in light of the affidavits that have been exchanged between the respective parties, I'm going to respectfully submit that the video footage is unnecessary today. And more than being unnecessary, it's also not appropriate and does not serve a legitimate purpose. And there are 3 reasons why. The first one is, by and large, the allegations made by the Commission have now been admitted, answered to, and amplified by my client and the people deposing on his behalf. So the footage is not necessary because the footage is not needed to prove admitted facts. You don't need to lead the evidence to deal with admitted facts. That's point number 1 as to why it's inappropriate. Point number 2 is that the footage is an inappropriate form of evidence in light of the fact that, and you will know this because this is dealt with explicitly by my client's treating doctor, that things like video footage and geolocation footage or geolocation information and so on does not have clinical value.
Sorry, what noun did you use? It's inappropriate what? It's inappropriate? After inappropriate, what's the noun you use?
Oh, inappropriate form
Okay.
of evidence.
Oh, all right, thank you.
Inappropriate form of evidence because ultimately what underlies the Commission's concern and the Commission's complaint regarding my client's postponement is a medical issue. And so this geodata information or CCTV footage or whatever it is, on its own, not being led through a clinician, and not being analyzed by a clinician or responded to by a clinician is inappropriate secondary evidence, which is being used to gainsay the medical opinion expressed about that exact approach.
Are you talking about Durbanville? Or
Yes, Durbanville.
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 Can you please explain your point about it relating to what may have to be attended to by a medical practitioner?
Yes. May I just ask Ms. Madlanga for some
Because
assistance?
let me tell you why I'm asking you this. I see it as objective material which says he was there.
Yes.
So I don't see the connection with what a medical practitioner might have to say on the issue.
May I respond?
Yes,
Give two
yes,
responses. The
yes,
first response
yes.
is that it's also accepted that he was there. So it's unnecessary because it's an admitted fact between the parties. There's no need to lead the evidence. But the secondary line of reasoning, and this is where I need Ms. Madlinga's assistance, but she'll hear me in response to you, Commissioner. I'll give you the reference after the fact, is this. The medical practitioner says that the Commission relies on a bunch of evidence, such as CCTV footage, Apple Pay data regarding payment accounts, movement data gleaned through geolocation data. And the position of the clinician, for reasons that you know which are recorded on the papers, is all that demonstrates is movement of some kind, but that the movement of some kind, the fact of the existence of the movement of some kind, is of no value in determining the clinical issue as to why the client cannot attend or attend the commission to give evidence. So the point as to inappropriate is that it doesn't deal squarely, with all due respect, with that clinical issue, and particularly in circumstances where the clinician has raised doubt about why it's being used in the manner in it's being used.
I get you on your first point, which is why flight that footage if there is no dispute about his location on the day and at the time. I get your point. I'm not sure that, one, you need the second point, and two, I am not subject to whatever else you may say. I'm not convinced by your second point. But please continue. But I stress that you don't, in the face of your first point, I'm not altogether sure that you need the second point.
That's where,
on this issue, it's a very weak point.
I think we're ad idem on the first point. And what I would say is that if those facts are not in dispute, then needing to flight the footage so as to prove something that's not in dispute is unnecessary. And
you see, your second point would make sense if the flighting would be for the purpose of showing that by being there, the medical condition relied on simply does not exist. If that was the purpose, I would understand your point.
Yes.
I'm not necessarily saying that Ms. Hassim is not going to argue that.
Yes.
I do not know what she's going to argue. But perhaps until she has argued that point, as I say, from where I'm sitting, I don't think you need the second point, and I repeat, I think it's a weak point for purposes of this should not be flighted.
well, let me accept the invitation then to simply say, if my learned friend, well, I'm caught between a rock and a hard place, because during my learned friend's submissions, she may flight the exact footage to make the exact point that chair is putting to me, which is because he was at X place, that brings into doubt the medical evidence. And in fact, that is the Commission's case, because you know, in their affidavit, they call my client, with all due respect, gratuitously an inverse outpatient. So the very attitude of the Commission, through the evidence leaders, is not to say that, oh, this is a benign piece of evidence, the CCTV footage. The entire thesis underlying their opposition to the postponement and why they want to tie down my client to a specific date is to say the fact of these movements, the fact of these payments, the fact of that he's not in the hospital all the time brings into doubt the medical diagnosis that the clinician has given him. And that's the further reason as to why we need an independent medical exam. So may I just finish on this,
Yes,
please, Chair?
by all means.
If my learned friend is not going to push that line of argument today in front of you, then I don't need the second point. But if my learned friend is going to push that point, then I do need the second point, even if Chair says he's not convinced that it's a strong one.
You see, just to make sure that I will not be misunderstood, the question whether Mr. Carrim's movements show a pattern that is at odds with what we have been told, that's central to the evidence leader's case. So what I said earlier did not suggest that Ms. Hassim is likely not to argue such a case.
Agreed.
But I'm making a different point. That case can be argued without the need to actually flight the footage.
Agreed.
Why not? Exactly because it's agreed that at the time, on the day, Mr. Carrim was at a shopping complex in Durbanville.
Agreed.
So that point can still be made, or that argument can still, but as I said, whether Ms. Hassim will actually want to flight the footage, we'll hear her when she says so.
Indeed.
Yeah. Shouldn't we leave it there and move on?
Yes,
please?
I'm happy to. Can I just give you one reference, if I may?
Yes.
If you look at paginated page 94 of your pleadings bundle in the postponement, paginated page 94, you'll see the heading, it's geolocation data and its clinical significance. The basis for the submission that I was making to you comes from paragraph 45 on that page, as to why flighting that is unnecessary over and above the reason that Chair has already identified that it's not in dispute. So I'll just leave that, if I may. What Ms. Madlanga is doing is she's looking through the Commission's papers to give me the reference, the exact reference of where this debate arises from in the way that Chair posits it to me. So Ms. Madlanga will give me that reference shortly. Can I also just say this? This moves me on to point number 4, 23 minutes in. Point number 4 is this, is that the medical evidence in front of you from Mr. Carrim's treating clinician is undisputed on the clinical diagnosis and the clinical observations that Mr. Carrim's treating medical professional makes. There is an expert report, and I'm not even going to mention the expert's name, put up by the Commission, which generously doesn't actually dispute that clinical observation. What it does is it speaks to 2 collateral issues. The first one, which with the greatest of respect to the expert is an invention of his own, is he talks about it being inappropriate for Mr. Carrim's physician, Mr. Carrim's medical practitioner, to perform what is called an independent medical exam on Mr. Carrim. It's referred to in the document as an IME. The simple point about that IME and why then it can't be used as a basis to impugn Mr. Carrim's medical doctor's clinical observations is Mr. Carrim's medical doctor never performed an IME. An IME is an entirely separate form of medical examination that is performed in a forensic context where there needs to be, understandably, a degree of separation or independence between the medical examiner and the ultimate patient. But in this particular instance,
how do you describe forensic in this context?
when you say in this context...
Or rather, let me leave out in this context. How do you
Let's say,
describe
like,
forensic?
Chair, this goes back to that discussion you and I had the last time. If we were in Uniform Rule 36 territory, and you'll remember you and I had the discussion about Uniform Rule 36 as a parallel mechanism through which examinations occur in instances of medical negligence claims. That's the forensic parallel that I would say the IME concern arises in.
I would understand the rule to be the vehicle in terms of which you get to
Yes,
the whatever it is the medical practitioner
Yes.
has to do.
yes.
That doesn't necessarily answer my question, I don't think.
Well, the difficulty in answering the question is that I'm trying to distinguish what the Commission's expert report criticizes Mr. Carrim's medical practitioner for allegedly doing and why it's inappropriate. And I'm responding...
Let's take, for example, the context of criminal proceedings where the rule you are referring to would not apply at all. I would imagine that even in that context, you can talk forensic when medical practitioners
Yes.
are involved.
Yes.
So it's on that basis that I'm saying, how would you describe or define forensic in a way that, for example, would exclude what we have been given here? Why is it not forensic here?
Because, and that's the exact criticism that the Commission's expert attempts to make, is that the Commission's expert, as we understand it, says that the treatment Mr. Carrim is receiving can never be an IME exercise because he's not, in inverted commas, independent enough of Mr. Carrim. And the point I'm making is that's exactly correct, because the treating doctor is not performing an IME for some forensic, independent, objective, evaluative purpose, like under a Section 79 inquiry or under a Rule 36 type inquiry. He is the patient's, Mr. Carrim's, own treating doctor. So he doesn't, the point I'm simply making is that the basis upon which the Commission's expert, it seems to undermine the clinical evidence in front of you from that doctor is to say he's not entitled to perform an IME and what he's given you is not an IME. And we're agreeing with that because we're saying the treating doctor is doing something fundamentally different. So that's the first point that I was making.
Please continue.
The second point that I was making, to the extent that that report is relevant in front of you, is that that report itself emphasizes the role to be played by Mr. Carrim's own treating doctors before any such directive can be given that he's subject to the medical examination of another. And you can find that at Annexure MT1 at paragraphs 18 to 19. And it's also referred to in the evidence leaders' submissions at paragraph 47. So the very point is to say that the medical evidence of Mr. Carrim's doctor is unchallenged directly. To the extent it is challenged, it starts from an incorrect premise. But even